So yes, the other day we discussed about um, legal status of dead humans. So we had a quite detailed discussion about it. So the next important case where we have certain difficulties in defining the legal status is the case of unborn uh, person. Okay. Now the other day I told you that law recognizes personality of those who are born alive, and so those who are born alive, so from the moment of your birth till your death, that's the rule that we discussed. Okay, as has been recognized in various common law jurisdiction. So the general idea of natural person, okay, which we apply because of our speciesism to only humans, okay, is that who is a person? One who is a living human, okay, and who is born and who's alive. That means who's born and who's not dead yet. So once you die, you no longer have personality, as we discussed in the other class, obviously with certain exceptions, where certain rights or interests are recognized, obviously with the question as to whose interests are truly protected in those cases. So today we are going to discuss about another difficult topic, and that's about unborn. Now I told you that unborn could be understood in two different ways. One who is not yet conceived, okay, who's not in the mother's womb, and then those who are in the child, or you can say fetus, who's in the mother's womb. Okay, so you will see that even in these two cases, certain interests are recognized. And when we see how these interests are recognized, you will see that and there are certain conflicting justifications with regard to how these interests are recognized. So one thing, there are many different positions though. This is just a moral, it's more of a moral debate than just a legal debate, because a legal discussion would involve me telling you what the status of law is in different legal systems, be it under common law or be it under statutory laws as enacted by the legislations of those legal systems, and that would be the end of the debate. So, but it's not that simple, because the legal debate would quite often inevitably involve certain moral questions as well, and we cannot be ignorant of that. But for now I will just discuss the basics, then we can go into the specifics. Okay. So yes, the idea is that when it comes to unborn, okay, be it in the mother's womb or not even conceived, okay, and all the worse in the case of one who is not even conceived, okay, so they are not recognized as complete person, not recognized, even the ones who's in the mother womb, not recognized as complete person in the legal sense of the term. However, certain rights are definitely protected. Okay, certain rights are definitely protected. Now, unlike in the previous case of dead humans, we had to struggle with this idea of interest. Okay, whose interests are being protected? But here you will see that we have more cogent argument in favor of the interest being of the one who's being protected, that is of the unborn person. So, yes, their rights are recognized to varying degrees in different legal systems, okay? So, especially when it comes to inheritance, okay? So, for the purpose of inheritance, a child in the womb of her mother can acquire certain rights and also inherit property. However, this is subject to one contingency, that these rights are not vested rights, okay? So child in the mother's womb, okay, as is the idea in common law countries, can acquire certain rights and inherit property. To that extent, that right is recognized, but the right is contingent, okay? That means these rights are not vested and contingent on the child being born alive. So that's the contingency. The child has to be born alive, only then the right becomes vested. And even in India, if a child is in the womb of the mother, then such a child is taken into consideration while partitioning under the Hindu laws. So if you look at Section 20 of the Hindu Succession Act 1956, refers to right of child in womb. It says a child who was in womb at the time of death of an intestate. So some intestate is one who dies without making a will. And who is subsequently born alive, okay? Child who was in the womb and subsequently born alive shall have the same right to inherit to the intestate as if he or she had been born before the death of the intestate. So if born alive, then will be considered as if he or she was in existence before the death of the intestate, and hence inherit the property accordingly. And the inheritance shall be deemed to vest in such a case with effect from the date of the death of the intestate. Obviously, that's given, understandable. Obviously, the interest take effect only after the death of the intestate here. However, what is important here is that even though the child was not born, was in the mother's womb at the time of the death of the intestate, the child, by virtue of some legal fiction, is considered to have been already in existence, or have been already born, and accordingly the properties will be inherited, as is the rule under the law. So that gives us examples of recognition of certain rights of one who is not born yet, who is not born yet but is in the mother's womb. So that's the rule is. Now here you see that law to a certain extent recognizes certain kind of personality here. You can say that it's a case of recognition of right. Now whether in such case you call the unborn as a person or not, there are debates over that. But legally you see there is a recognition of right. Now morally the debate is whether such an entity, the fetal entity, should be considered as person or not. Some say that yet it should be considered as person. Others say that should not be considered as persons. Whereas there are those who say that should be considered as person, but that someone being person doesn't mean that all the rights are available to him or her. So that's the rule. So that's what we see. That certain rights are basically accepted in the case of, recognized in the case of one who's in the mother's womb. You can see similar matters. So these are related to property. You can see similar, provision also exists in the Transfer of Property Act. Not similar, but provisions in the Transfer of Property Act that recognize right of someone who was not born yet. So Transfer of Property Act 1882 essentially deals with transfer of property inter vivos. So basically transfer from one living person to another living person. However, there is a provision in the Transfer of Property Act, that is Section 13 of the Act, which can be considered as an exception to the rule. But when you look at it properly, you need not have to understand it as a case of exception, but maybe an example of how it is to be understood. But yeah, you can broadly say, well, maybe this is an exception to the rule that transfers are only allowed inter vivos, basically between two living beings. So what does Section 13 of Transfer of Property Act say? The Transfer of Property Act 1882, Section 13 reads like this: that transfer for the benefit of unborn person. So you can transfer. It's not saying that transfer to the unborn person. Because if it is a complete transfer, then there is a vested right created right at the moment of transfer. But that's not what's happening. It's saying that transfer for the benefit of unborn person. It uses the word person, but not to be understood in the same sense, the complete sense of person. So what does it say? So it goes like this, that where on a transfer of property, an interest therein is created for the benefit of a person who is not in existence at the date of the transfer. So it's talking about where on a transfer of property. So it's talking about a transfer of property that happens, okay? But through that transfer of property, an interest is also created therein, okay, for the benefit of person, okay? Now, person is not to be, as I told you, to be understood in the complete sense, okay? Person not in existence at the date of the transfer. Okay, so this person does not yet exist, okay, need not even be in the mother's womb. That is also allowed, okay. So an interest therein is created for the benefit of a person not in existence at the date of the transfer, then subject to a prior interest created by the same transfer, okay. So there has to be prior interest created, okay, subject to prior interests which are created by the same transfer. The interest created by the benefit of such the interest created for the benefit of such person shall not take effect unless it extends to the whole of the remaining interest of the transfer in the property. Now it doesn't say anything more than that. It has to be read in the context of, along with section 14 of the Transfer of Property Act. Now what are the requirements that it lays down? Okay, so you see that this allows for a transfer, okay, of property in favor of someone. Okay, it's not a direct transfer because it does not create any interest immediately, okay. Basically deferment of the interest that is created, okay. So it's saying that you can in fact create interest in favor of someone who does not even exist, okay, who's not born yet, who does not even exist. How can you do that? It says that you can do it, two different ways. You have to create prior interest. It says that subject to a prior interest created by the same transfer. So you have to create a prior interest. You can do that, okay. You can create a trust, okay. So you can do that, or you can, if not trust, then what you can do is you can transfer certain limited interest, not the whole interest, okay, not the entire interest, okay, some limited interest, maybe some life interest, okay. You have to transfer that in favor of someone who's living, okay, or you can also create a trust. So you have those options available. Now the prior interest which is created in either of these cases that we discussed, okay, is in favor of a person until the unborn comes into existence, okay, until you create the prior interest until the unborn comes into existence. So unborn does not exist. There is no direct transfer between the living and the non-living, someone who does not exist. So the requirement of the law is that you have to create a prior interest, and the prior interest, can be created in favor of a person until the unborn comes into existence, okay. Now what happens? Now the next important requirement is that the unborn should be in existence. Well, it's not said here clearly, but if you look at 14, then you will see it there. We'll read that as well. The next requirement is that the unborn should be in existence before the death of the last life estate holder. So you may transfer the property in favor of multiple life interest holders. That is also allowed. That first the property goes to A, then B, then C, and then, if the unborn person comes into existence, okay. The unborn should be in existence before the death of the last life estate holder, okay. So the unborn has to be in existence. Now how are we to understand the existence of the unborn? Is it someone who's born, or is it someone who is conceived? So in such case, it is considered as child anvantrisam. So before the death of the last life estate holder, the child has to be in existence in the mother's womb. That's the rule. So that's the maximum deferment that is allowed. But if the child does not even exist in the mother's womb, then obviously no such transfers takes place. So this is what this particular section talks about. Now, as I told you, it is to be understood in the context of section 14 of Transfer of Property Act, okay. And what does Transfer of Property Act section 14 talk about? It talks about rule against perpetuity. So this is also relevant in the context of rights of one who is dead. Okay, and why is that the case? Well, the question is, how much should someone who's dead be able to have control over how the property is disposed is or dealt with once that someone is dead? Well, Section 14 of Transfer of Property Act imposes certain limitations that you cannot have control over the property from your grave. Okay, so there is a limit beyond which you cannot have that control, and that's something that you find in the rule against perpetuity. It says that you cannot have control over the property in perpetuity. So what's the rule? It says no transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living at the date of the transfer. Now remember, the life interest that can be created under Section 13, that's what is being referred to here. So it says no transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living at the date of the transfer. So yeah, you can create as many interests in favor of those who are living, subject to other laws, rules as they exist. And the maximum deferment, okay, that is allowed. And the minority of some person who shall be in existence at the expiration of that period, to whom, if he attains full age, the interest created is to belong. So that's the maximum deferment, okay? So you have to create life interest, okay, because the unborn does not exist. And then what is the maximum time that is allowed for the vesting of the right? That would be that before the death of the last, life estate holder, the child should be in the mother's womb. So the gestation period, okay, period during which the unborn is in the mother's womb. And then from there, from the day of birth, maximum deferment would be the age of majority. So if a legal guardian is, there, then 21, and if not, 18. So that's the maximum deferment that is allowed. So one who is dead can have that much control over the property and not beyond under this particular law, as it applies to Hindus, does not apply to Muslims. So yeah, so if you add the contingency that only if such a person reaches the age of majority, then that remains a contingency, but that's not our discussion. So what's the discussion here? You see that in such situation, these provisions basically tell us that a transfer is allowed in favor of someone who does not yet exist, okay, who's not even in the mother's womb, but law to a certain extent recognizes certain right. The question though is, whose interest even in such case is being protected? Is it the interest of the one who's making such transfer? Definitely that's the case, because that's the interest, that is the wish, desire which is being recognized. But then once the child is born alive and fulfills the other contingencies, then obviously the child can have interest. So certain rights are recognized, okay, certain rights are recognized. But that right, it makes sense to call it a right only if the child is born and fulfills the contingencies, not otherwise. Now the requirement though is that, one more thing that I would like to add now, that will be discussed in more, detail next semester, I think, when you are taught Transfer of Property Act. It's not a requirement for me, but I will nonetheless tell you what the thing is. If you look at the illustration to Section 13, the idea is that you can create limited life interest in favor of any number of persons who are living. But prior to the death of the last living, limited interest, life estate holder, okay, the unborn has to be in existence, as 14 says, okay. But the interest that goes to the unborn has to be whole of the remaining interest. It has to be whole of the remaining interest, as Section 13 says. Okay, the interest created for the benefit of such person shall not take effect unless it extends to the whole of the remaining interest of the transfer of the property. What is the whole of the remaining interests? Basically, all the interests minus the life estate, interest of the life estate holder. So basically all the rights go. It cannot be a limited rights that go to the, the unborn. So illustrations provided. So A transfers property of which he is the owner to B in trust for A, okay, and his intended wife successively for their lives, okay. That's the trust, okay. After the death of the survivor, for the eldest son of the intended marriage for life. It's talking about eldest son, okay. And after his death for a second son. So you see that there are two sons that he's thinking about, eldest son, then second son. The interest so created for the benefit of the eldest son does not take effect because it does not extend to the whole of A's remaining. Why is it not whole of A's remaining? Because the eldest son does not get the entire property as per the transfer, because again there is second son who gets to get the property, okay. So if that means the eldest son does not get the whole of the remaining interest, that means such a transfer is not allowed under the law. Anyway, that's not the important part of the discussion here, though. You will discuss this in Transfer of Property Act. From having read these two different sections of Transfer of Property Act, 13 and 14, we can look at it from two different perspectives. One who is dead, okay, how much is that individual allowed to have control over the property after his or her death? That's what 14 tells us, okay. But 13 also tells that certain interests can be and are recognized, okay, property interests are recognized of someone who's not yet born. But does it really make sense to say that it is a matter of right? It becomes a matter of right only when that being is born. Then you can say that, well, it's a matter of right, okay. But until even exists, it seems to be more of a protection of the one who's making the transfer than the one in whose favor the transfer is made. So that's what we have, okay, with respect to unborn and property generally. Now, under the law of crimes, okay, under criminal law as well, you will see that certain interests are recognized of one who is not yet born, okay, who is not yet born. It's not explicitly said anywhere, okay, but you can clearly see that state shows some kind of interest in one who is not yet born, okay, in the fetus maybe, or unborn child. When you say child, there involves a kind of personification and some kind of there involves this idea that unborn has the same moral importance as that of one who is born. So anyway, so you see that under criminal law there is a recognition of certain interests, okay, and the degree of that interest, okay, which is recognized, and the concern that the state shows progresses as the fetus develops in the mother's womb. So although these provisions from IPC that I'm going to refer to are less relevant because you now have MTP Act, but these nonetheless point us towards certain very important questions, okay, that to what extent does the state recognize the interest of one who is not yet born under the criminal law. So if you look at section 312 of IPC, it deals with causing miscarriage. And how does it define that? It says, whoever voluntarily causes a woman with child to miscarry shall, if such miscarriage be not caused in good faith for the purpose of saving the life of the woman, be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. If the woman be quick with the child, shall be punished with imprisonment of either description for a term which may extend to 7 years. So what is important here? It says, if such miscarriage be not caused in good faith, so that's the requirement is there, okay, for the purpose of saving. So that has to be an exception because quite often you need to save the lives of women. So in such case, it is allowed. So you see that here as well, the unborn and the mother is not treated the same way. They're not given equal moral importance. The mother is preferred here. But although it's problematic, we're going to discuss that. But you see that there is still a gradation here. Okay, be punished with imprisonment of either description for a term which may extend to 3 years. Okay, so if it is not quick, okay, with the child, basically, when is a child, when is a woman quick with the child? When the woman, starts feeling the movements of the fetus inside. So until that happens, the punishment is 3 years or with fine or both. And if the woman be quick with child, and shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. So you see the punishment increases, as the fetus, evolves. So in such case, under this provision, even the woman, herself would be liable if she causes herself to miscarry. This is a very old law. So that's not going into other questions here. This is merely to point out that the state shows more interest in the entity, okay, in the fetus, as it develops, okay, as it comes closer and closer to being viable and ultimately being born alive. So you see how state takes more, recognizes the interest of that entity as its development progresses. Now, at the same time, you can also look at, as now you have specific legislation that deals with these matters. So that you have in India, you have Medical Termination of Pregnancy Act 1972, which is now being amended in, I think, 2020. Has been passed in certain amendments, has been passed in the Lok Sabha, but not yet in the Rajya Sabha. So yeah, so what does the act say? Okay, in its original form say. So even in the act, you will see certain gradations. So if the pregnancy does not exceed 12 weeks under the MTP Act 1972, the pregnancy can be terminated based on single opinion formed in good faith. So you can take the opinion of a medical practitioner. Obviously, the qualifications are laid down, but you need opinion of only one practitioner in good faith. Okay. So I think 1 to 12 weeks your first trimester, but from 12 weeks, exceeding 12 weeks, okay, but less than 20 weeks, you need opinion of at least 2 doctors. So state is little more cautious as the pregnancy progresses. So in such case, how is the opinion to be formed? Okay, so there are many different grounds which are provided. Okay, so those are, for example, the continuance of the pregnancy would involve risk to the life of the pregnant woman or of grave injury to her physical or mental health. So here you see that priority, importance is given to the life of the mother over that of this entity. So yeah, the continuance of the pregnancy would involve risk to the life of the pregnant woman, okay, or of grave injury to her physical and mental health. If that's the case, then the same opinion can be framed. That there is substantial risk that if the child was born, it would have suffered from such physical and mental abnormalities as to be seriously handicapped. So this is a right against, as has been interpreted in Western countries not under this law, but under law of tort, okay, as a case of wrongful life. Okay, doctors sometimes fail to do the proper diagnosis and tell the prospective parents of certain serious deformities that the child may be born with if the child is born. So in such case, you have those cases of wrongful life under the law of tort. We'll discuss that. Okay, but this could be a ground, okay, for abortion. So that opinion could be framed for this reason, that there is a substantial risk that if the child was born, it would have suffered from such physical or mental abnormalities as to be seriously handicapped. And in certain cases, the assumptions are, almost, easily made. Okay, those would be in cases of rape. Okay, and failure of contraceptives. However, with respect to rape, the problem, as you know, in India is that there is no rape recognized within the marriage, as you have also heard of the remarks being made by judges. Can we call it a rape? Okay, even if it involves brutality, etc., and all those. So that's a problem we need to address. That needs to be addressed. However, if it is outside the marriage, then you obviously assumptions can be made in case of rape, which is obviously insufficient and needs to be fixed. And apart from that, in case of failure of contraceptives as well. So in those cases, certain assumptions can be made. But why am I talking about this? Because so after what happens, you can also ask what happens after 20 weeks. Well, after 20 weeks, you do not have any such. So in such case, you have to approach the court. Okay, maybe under you have to file a writ petition if it is beyond 20 weeks, and you have a ground then. So that was the status of law as it existed. But what I was trying to tell you guys is that you see that the state gives more importance to this fetus as it progresses. Okay, and in the United States as well, in the famous case by the name Roe versus Wade, also this particular right was recognized. So this is a case which was decided in 1973 in the United States, and you see our act is from 1972. So so it's a very important case, and the court, in the Supreme Court, United States Supreme Court, had held that it basically held that pregnant women have liberty to choose abortion without too much interference on the part of the government. The government cannot completely restrict.
Sir, could you please repeat the name of the case?
The case goes by the name Roe versus Wade. I'll type it here. Just a second.
So wasn't this the case that was overturned or something during the Trump regime?
Yeah, I mean, not really. Was it overturned? No, not really. I mean, but before that, you have other cases, though. I'm referring to it in the historical context. Okay, you have Roe versus Wade, then Planned Parenthood versus Casey. So you have all these cases, and was it completely overruled, though? No, I don't think so. I mean, do you have the judgment where it says that it was completely overruled?
No, sir, I don't have a judgment, but I remember during Trump's regime there were
talks about it, but I don't think the the only difference that happened. Okay, in Roe versus Wade, they had this trimester test, didn't they? Whereas in case of Planned Parenthood, versus Casey, or Casey versus Planned Parenthood, they basically maintained the constitutionality of right of women to undergo abortion. Okay, but then they replaced the trimester test with this test of viability, which basically makes the viability of the fetus. So that will depend on the technologies as they develop, and there are questions there as well. Okay, what do you consider as viable, and does it really go in favor of women though? So that's there. But as of now, I'm not quite sure if there's any other judgment that overruled though. I don't think so. But if you have any example, I'm not aware of any. Okay, there was a talk because Trump was getting all these conservative judges appointed, and there was a talk about dilution of the laws. But till now, I'm not aware of any such case laws that overruled it completely, that you no longer have the right to undergo abortion. I don't think that has happened. But if you have any case laws, then obviously my remarks are subject to that. Okay.
Sir?
Yes, Sumit. Yes, tell me.
Sir, what was the second case? Is typing that.
Okay, so it's Planned Parenthood versus Casey. Okay, just a second. I will type it here. Planned Parenthood versus Casey. Okay. So you see what happened in these particular cases is that in the first case that I was referring to, that is your Roe versus Wade, the Constitution, I mean the Supreme Court of the United States of America held that Constitution protects the rights, okay, the liberty of women to have an abortion. So that means too much, complete restriction on women. Why is that even necessary there? Because southern states like Texas and all are conservative states, and there the laws, content of the laws quite often are very much determined by the faith of the people. The biblical, laws are truly believed in, and biblical ideas of morality are also believed in. And hence, in many cases, for example, you have heard about, I think, one in Alabama, where another law was enacted. So you hear about all such laws being enacted here and there that, significantly imposes restrictions on women's, liberty to have abortion. So some states, imposed restriction even when the child is born out of incest, okay, or for that matter, rape. There is no justification in any situation for the women to undergo, abortion. That kind of conservative, take is also there. Conservative in the sense that they are conservative of religious morality, religious belief, etc. And these also make their way, because these are conservative states. So these moralities also make their way into the law. And when you have law, would that law be justifiable? So in this particular case, in Roe versus Wade, it was held that, well, women have the liberty under the Constitution to undergo an abortion. Okay, but even in this particular case, the 3 trimester, test was basically there. Okay, so even in this particular case, it said that, during the first trimester, basically till 12 weeks, no regulation, little more regulation, so it will be regulated during the second trimester, but during the third trimester, abortions could be prohibited. Okay, however, that is also subject to the life and health of the mother. Now, this was subsequently, the right was recognized, the right continues to be recognized, but in the second case, that is Planned Parenthood versus Casey, again, the same was held, okay, that women have the right. However, they replaced the trimester test with this viability test. Okay, so when does the women when can restrictions be imposed? So restrictions can be imposed when the that entity, okay, becomes viable. So it basically said that the due process clause of the 14th Amendment provides protection to women to choose to have abortion. Okay, so much more liberty is given compared to the previous one, as you see, subject to the viability. So now, what is a viability? Viability is the idea that the baby is able to survive outside the mother's womb. Okay, now when does the baby become viable outside the mother's womb? And how are we to define viability? You know that if the baby is left on its own, it's not viable. Okay, so some care is needed. So the same goes for even in mother's womb. So so the idea is this, that if the baby is brought out of the mother's womb, it will be based on this care which is provided, okay, be able to survive on its own. But then that's little problematic, as I understand. Okay, my understanding is that it will depend on the developments in science and technology. Maybe you can have science and technology develop to an extent where the baby becomes viable much before than they are today. What about then? So all those things are still there, but the idea is nonetheless this, that little more liberty was protected in this particular case, as I understood. Okay, now I do not know, okay, I plead my ignorance of any such case laws in which it was overturned that completely. However, modifications may have been made here and there, but these two are some prominent cases I thought you should know. However, there is another argument when it comes to pregnancy, that women should have complete say. Okay, now let's look at another improvement that was to be made, okay, in India, and I think let me just find out you have this medical termination of pregnancy amendment bill 2020, which was passed in March 2020, and it made certain changes, certain progressive changes, you may say. Many say it's not progressive enough, which we can have a discussion on. And what are the changes that it brings? So it basically, like the previous one, regulates the conditions under which the pregnancy may be ended. Okay. However, the time period, as we discussed, has been changed under this bill. Okay. So what is the change? So if you remember earlier, up till 12 week consultation with one doctor was, opinion of one doctor was sufficient, but 12 to 20 you needed two. Now till 20 weeks, opinion can be framed by one doctor. So the bill allows abortion to be done on the advice of one doctor up to 20 weeks, and between 20 and 24 weeks you need two doctors. So you see 4 weeks extended. Why is that? Because quite often many abnormalities, deformities that the child may be born with, complications, are not detectable until that later stage. So 20 weeks, pretty arbitrary. And if it is beyond 20 weeks, then you have to then go through this entire elaborate court procedure, which is very difficult. And for common people, you know how much difficult it is. Okay. And in India, lots of shady practices happen, where people because of this unnecessary illegality sometimes imposed, lots of women have to subject herself to all such unsafe abortion that happen here and there. Well, I do not have any proof of it, but we all know, so I do not have any empirical data to say that, but we all know, and it's known. Many studies have also been done. So basically, based on that, this extension has been made. So it's now deferred to 20 to 24 weeks, and during that period, you need opinion of two doctors. Now, beyond 24 weeks, again the same judicial process. Okay, no, sorry, beyond 24 weeks. Okay, under this bill, the states are supposed to set up medical boards. Okay, state level medical boards, to decide if the pregnancy may be terminated after 24 weeks. Okay. Now, why is that? So that one does not have to go through this same judicial process. Okay. One doesn't have to go through the same judicial process, that you do not have to go for writ and all that. Now, the question is, this medical boards which are to be set up, how accessible will this be? Okay, because these are set up in specific cases. How accessible will those medical boards be? And you need 3 doctors, who specialize in 3 different departments. Okay, so anyway, those are not jurisprudential questions directly, but you see the difficulties. Okay, I think you need one gynecologist, one obstetrician, and one radiologist, I think. So the boards are set up like that, okay, and the decisions are taken based on the boards. So it has to be board's decision, basically. Okay, and is available after 24 weeks if there are substantial fetal abnormalities. Okay, now you see that it is allowed only in case of substantial fetal abnormalities. That's the case. Okay, so what do you do then? Well, if that's the case, then the board will be constituted, and if the board thinks that there is case of substantial fetal abnormalities, then it will be allowed. However, it is not accessible to everyone. That's the problem with this particular rule. So it seems to be a law which is elitist in its approach. So it has to be made more accessible to the people generally. There are many other problems, but these are some of the problems that I think I should highlight. However, there are other claims though with respect to this, that why restrict it to only 24 weeks? Why not leave it completely up to the wish, up to the liberty of women? Why liberty is protected only up to certain times and not beyond? That's something that is a debate, not just in India, in many different countries. So that's something that we can have discussion on, but today I want to complete this topic, and maybe in the next topic we discuss about the moral questions which are involved with respect to abortion. But you see that state, you see from analysis of all these provisions, you see that at the beginning of the pregnancy much less importance is given, okay, but as it comes closer and closer to being born, okay, so in the US they have this viability test, okay, um, you see that the interest, the state starts asserting more and more interest, okay, in the protection of that entity. Now it's fetus, isn't it? But at some point of time people start treating it as not just fetus but also as a child who is not born, okay, and when we refer to it that way, we treat it as humans, okay. Now one argument is that, well, it is not human, okay, it is not person until it is severed from the mother's body. So until the it's born and umbilical cord is cut, but so until that, okay, as the moment it is out of the mother's body, it's now separate, and state obviously, even if the baby is not able to survive on its own, the state asserts some kind of control over it. In reality, the state doesn't really do much, as you know. So many babies are born, and then they die from starvation, lack of health and all that. But that's a separate debate. At least in theory, it says that yeah, we have control over it. Okay, we have interest in its protection, which is necessary as well. No denying that. My point in saying that is only this, that a state needs to do much more than just this once the baby is born. Now, before that, the idea is that because it's still dependent on the mother, it does not have separate existence, so it's not entitled to the same level of protection as one who is born would have. Okay, so that's the argument. So that's something that we will discuss. Okay, whether as it progresses, as it becomes more and more viable, I mean, what should we prefer now? I mean, should we? I mean, what should be preferred? The autonomy of the mother, or the woman, or is there some interest in the life? Or should we consider the life of this entity as having the same value as that of the mothers? Okay, all those questions do arise, but we will discuss that in the next class when we discuss about morality, questions of morality when it comes to abortion. But the basic idea is quite clear to you. As it becomes more and more viable, okay, the state asserts more and more interest. So that's under the criminal law. Now under the law of tort, okay, interest of children, child who is not born yet is also recognized, okay, but it varies from varies in degree. How is that? So under tort law, a child may claim damage sustained by her if she was in her mother's womb. So if the child, so in such case it's very clear, if the child is in mother's womb and if she sustains some damage, some injury while she was in the mother's womb, then she may claim damage. In more and more legal systems, it's being clearly recognized. In the law of tort, when you were taught, you might have already heard of enough such cases. However, the condition here is that the child has to be existing in the mother's womb. That's the condition. But does that mean that there are no cases where certain interests are recognized of one who is not even born? Well, we have those as well, but we have fewer of those cases. And does that mean that one who is not even in the mother's womb, their personality is recognized? Well, that's something that we will discuss. But for now, our understanding is this, that a child who is in the mother's womb, exists in the mother's womb, okay, their rights are recognized. But one who has not yet been conceived does not have this level of right, okay, does not have such rights. Now, does it make sense to say that they have rights? Is a question that we have to deal with. Now, why is that though? Why is that though? The reason is that the difficulties that we have in determining when a fetus was alive and when it died. So basically, the causal connection, establishing causal connection becomes difficult. But in today's time, with the kind of development in science and technology, we have to also allow changes in the law. We need changes in the law as well. Okay, so if we have cogent scientific proof of the harm suffered by the fetus, okay, and the causal connection can be established, then why not impose liability? That's something that is very important. Okay, and the development of law in this direction is that with the developments in science and technology, more and more cases are there in which such rights have been recognized, even of one who was not even in the mother's womb. Okay, so you have these two problems. Okay, so basically technological problem. We do not really know when the baby was alive and when it died, and whether the death or the harm was suffered as a causal connection of whatever was done. Okay, of whatever negligent act or others was done. However, as the science and technology develops, okay, technology in this area develops, obviously more and more cases will be there where the same is recognized. So in India, we have a case, okay, very famous case, the Union Carbide Corporation versus Union of India. In that particular case, you see that this right has been recognized. So I will, however, what you see is that in this particular case, the court provided that, just a second. In this particular case, the court took that insurance model, okay, to basically provide compensation, damages. That's the model that they took. So it's the UCC versus Union of India, authored by Justice Venkatachalya. Okay, so in this particular case, what does it say? I will refer to the relevant portion. Okay, so it says in para 77, then comes the question which we posed at the end of paragraph 44. Okay, this concerns the exposed member of the populace of Bhopal who were put at risk and who, though presently asymptomatic and filed no claim for compensation, might become symptomatic in future. So you have law of limitation related question there, but anyway, I'm not going to deal with that. And secondly, how should cases of yet unborn, okay, children of mothers exposed to MIC toxicity, where the children are found to have or develop congenital defects, be taken care of? Okay, so how do we deal with that? So it was not those unborn who were exposed to, it was their mothers who might have been exposed to, and as a result, the children were born later on with congenital defects, and that wouldn't have happened had it not been for the exposure that their mothers had to suffer to this MIC, methyl isocyanate gas. So it further says, so they decide who is to pay the compensation and talks about general insurance compensation and all that. Okay, it further says that the insurance will cover virtually serve to render the settlement an open-ended one so far as the contingent class of future victims, both existing and afterborn, are concerned. The plausible claimants fall into two categories: those who were in existence at the time of exposure and those who were not yet born and whose congenital defects are traceable to MIC toxicity inherited or derived congenitally. Insofar as the second class of cases is concerned, some aspects have been dealt with in the report of Law Commission in UK. It's referring to the report, and what does it say? It says claims for damages for prenatal injuries have been made in many other jurisdictions, but there is no English or Scottish authority as to whether a claim would lie. This is referring to the Law Commission in UK. And if it did, what rules and limitations should govern it? In our working paper, we did not attempt to forecast how such claim would be decided if it came before a court in this country, although we did add, as an appendix to the paper, a brief account of some decisions of courts in other jurisdictions. It is, however, important from our point of view to express our opinion, reinforced by our general consultation and supported by the report of the Scottish Law Commission, that it is highly probable that common law would, in appropriate circumstances, so this is very important, it is highly probable that the common law would, in appropriate circumstances, provide a remedy for a plaintiff suffering from prenatal injury caused by another's fault. It is important to make our opinion on this point clear, because on consultation it has become apparent that many people think that we were in our working paper proposing the creation. Anyway, whatever. So it's referring to something, okay, where there is a probability of recognizing the same. And it also refers to the Congenital Disabilities Civil Liability Act in the UK, 1976, and sections 1 and subsection 1 says, if a child is born disabled as a result of such an occurrence before its birth, as is mentioned, okay, whatever in below, and a person other than the child's own mother is under this section answerable to the child in respect of the occurrence, the child's disabilities are to be regarded as damage resulting from the wrongful act of that person and actionable accordingly at the suit of the child. So in such case, what you see is that if the child is born with congenital disabilities, okay, then there is a remedy that the law provides, okay, in India under this particular case, and in Britain, okay, under the Congenital Disability Civil Liability Act, okay, as we just discussed, okay, 1976. So that's there. So you see that if it is traceable, okay, if you can trace scientifically, medically, that the harm suffered has been due to the negligence of someone, even if the child was not even born, as you see in UCC versus Union of India, it is that right is recognized. But it seems that that right is recognized if the child survives. If the child doesn't survive, then maybe claims can be made by the parents who suffer due to. Then, however, those claims will be made by the parents. So anyway, as you see that in Britain, okay, they have Congenital Disability Civil Liability Act 1976 that permits action for injury to an unborn child in certain cases. Okay, it talks about and that this child is allowed to sue even the mother though. Okay, even the mother is allowed to be sued by the child. So even child can sue his mother if he suffered prenatal injury when his mother was pregnant and was driving the motor vehicle negligently. And it can also extend to the father. So for example, if the father assaults the mother and leads to any harm to the baby, then the baby can definitely make claims. So this is being recognized increasingly in different countries. So there is another US case, okay, by the name Smith versus Brennan. Okay, just a second. Okay, so yeah, we have another case by the name Smith versus Brennan. Okay, in this particular case as well, certain claims were brought by infant plaintiff. Okay, so an action was brought by an infant plaintiff for injuries sustained while in the womb of his mother, resulting from what? An automobile collision due to the defendant's negligence. Now, the plaintiff was born 75 days after that incident happened. And because of that, the plaintiff was born with certain deformities. When the matter was taken to the trial court, the trial court granted defendant's motion to dismiss. Okay, and what was the ground? That the state of New Jersey, where the matter happened basically, recognized no cause of action for prenatal injuries. So they said that, well, common law under the laws of New Jersey, no such, or even under the common law as it existed, no such rights or cause of action are recognized for prenatal injuries. However, when the matter went on to appeal to Supreme Court of New Jersey, it reversed the decision and again remanded it for trial. Okay, and it said that an infant has legally protected interest in beginning life with a healthy body. So what kind of interest is recognized? It is that an infant has a legally protected interest in beginning life with a healthy body. So if that's the interest which is recognized, is it the interest of an unborn or is it the interest of someone who is born alive? Is a question that we still need to address, okay? So if another's wrongful conduct causes, that child to be born, deformed, then it held in this particular case that the infant may recover damages, okay? But when is the right, recognized? So the question is whether it's the case of fictive personality of unborn person. Is it a question of recognition of personality of an unborn person? Doesn't seem so from the explanation, because it says that it is an interest that the infant has as a legally protected, a legally protected interest that the infant has in beginning life with a healthy body. So that seems to be a right, an interest which is protected when the child is born. Okay, only then would such right be recognized. So it seems more to be a case of someone who is born, and then thereafter the recognition of that infant's right to begin life with a sound mind and body. Similarly, parents have been held, liable for ingestion of alcohol, smoking, or taking drugs, which results in, uh, certain defects in the children who are born. So that's also there. But I'm talking about mature legal system where these are even topics of discussion in our countries. Well, anyway, but it's nonetheless important discussion that we need to have. So yes, that's what had happened, okay, in that particular case. Now, Smith versus Bannon was also decided based on, there were other previous cases in the United States where no such rights were recognized, okay. No such rights were recognized, okay. And why is that? So, for example, one case is by the name Stemmer versus Klein. And there are many other cases where no such rights were recognized. There were many reasons, okay. Some reasons would be that common law does not recognize this, that there are no such legislations. But one argument that, used to be, there is that the child is not yet separate from the mother's body. Yes.
Sir, it's 12:30.
Okay.
We have another class. Ma'am is
Okay.
waiting
Sorry.
there.
You guys should have reminded me early. I forgot completely. Sorry.